Welcome to today's conversation about workplace age discrimination. My name is Janine Vanderberg, CEO of Encore Roadmap. And what Encore Roadmap does is make the business case for older workers and intergenerational teams to employers. We champion stronger workplace age discrimination laws, and we also provide tools, resources, and workshops for people at the Encore stage of life. So I am thrilled to be having this conversation today because it kind of achieves all of my goals of making the business case, championing workplace age discrimination laws that are stronger, and also providing an incredible resource to those of you here. Before I go ahead and introduce guests, just a few agreements. We are, because of the number of people joining us, we are going to have everyone on mute. I do want you to feel free. The chat is open to share thoughts and chats and resources in the chat. So go ahead and type them in as we go along. And I would just simply ask this, if we could show respect to each other. So feel free to share your opinions in the chat, but let's not start arguments in the chat if we could. We are going to literally, we are starting on time. We are going to end exactly in 1 hour. And we received an overwhelming number of questions. What I have tried to do is clump them into categories. We are going to try to get to as many as possible. And what I've done is prioritize the questions that were asked by the most people, if you will. So we're going to try to, again, and Gary is so gracious in sharing his time with us, we're going to try to get to as many as possible. Please stay until the very end. Gary has graciously agreed to donate a 1 hour free consultation to the winner of a drawing at the end of our session today. I'm going to go ahead and put together a really simple form in the chat. It basically asks for your first name and email address. So if you are interested in being entered into a drawing to be able to chat with Gary, I'll ask you to go ahead and fill it out. I will pick a winner using a random drawing solution after this chat, and then whoever wins, I'll connect you with Gary. So with that, it is my pleasure to introduce Gary Phelan. Gary has practiced employment law for the past 35 years, primarily representing individuals. He's a frequent speaker on employment law, and I just learned also on radio and television talking about this topic, and co-authored 2 legal treatises on employment law topics. He also teaches courses in employment law negotiation and mediation as a law school professor. And some of you may have met Gary in our last 2 coffee chats because he's been participating in them. So Gary, I am so grateful that you are here. Thank you so much. This is such an important topic for so many people, and really, really appreciate your donating your time today. So I'm going to go ahead and get started with, I think, defining some terms. This is supposed to be a conversation about workplace age discrimination. Tell us what workplace age discrimination is and how does it show up, either at hiring stage, promotions, layoffs, or anywhere across the life course of work.
Thank you, Janine, for inviting me to speak. The age discrimination is certainly something that is growing in many ways. And there's basic, the age discrimination, like other forms of discrimination in the workplace, manifests themselves in a variety of ways. Some like what you just mentioned with respect to hiring, with respect to promotion, particularly with terminations, with people tend to wanting now to work longer. And so what you have so the first thing, somebody calls me with a potential claim case. The first thing I do is ask before I even talk about what the law is what is your objective in contacting an attorney? But the law covers, and I'm going to be talking about the federal law because again, we have 50 states. So states have Many states have their own laws. Many just parallel the federal law. Some, like Connecticut, like New York, have more expansive laws. So I'm going to just be focused on the federal law. The first thing is you have to be somebody who's over 40 years old. Second is qualified for the job. Third, that you
Wait,
have to have
wait. Okay, Gary, tell me what that means. What does qualified for the job mean?
good question. And qualified is less, it's a less difficult standard. You have to meet the minimum qualifications for the job. Okay. So occasionally I'll in a case where there's a criticism of job performance of somebody who's been working there 15 years, might just say, well, based on the case law supporting, on that issue, they did the job for 15 years, so they could do it. So it's not a hard standard, the minimum standard, and that's not the focus in an age case. The third is on, that they suffered some sort of adverse employment action. Now, there's been a major decision in the last year by the Supreme Court that actually expanded what that meant. In the past, it's always, it's generally been some sort of significant loss, something tangible, such as a termination, a demotion, a substantial pay cut, some sort of substantial loss. The Supreme Court expanded that to just say some harm. And so something like in the past that it may have been somebody gets a bad performance review after having a lifetime of very good performance reviews in the past. That would have been that they would have not had suffered an adverse employment action. Now that would meet the criteria. The last is that the termination or whatever the adverse employment action is happened under circumstances which give rise to an inference of discrimination, like some indication of discrimination. Now, that can happen in one of two ways: directly, direct age-related comments, illustrate some sort of, Gary, you're getting too old for this job. Statements like that, and they do happen.
Gary, I'm sorry, let me interrupt you for a moment because
Sure.
in our last coffee chat, and I've heard this from another people, is it considered an adverse thing if somebody keeps popping by your desk and saying, "Are you ready to retire yet?"
It depends on who it is.
Yeah.
The two extreme examples. If it's the CEO who does that, and then you say no, and 2 weeks later you're terminated. That's a classic example of what would be a good claim. If it's a coworker, and when I've had cases where this is an issue, inquiries about retirement. Inquiry about retirement itself is not considered discriminatory. Inquiries about retirement, along with some sort of job actions that are, somehow, that are within a relevant time frame, they may be strong evidence of discrimination. So a lot of it, and often what I'll hear is, well, they were just curious, and so, and who makes the inquiry is also extremely important. So the first is that, and so that's their direct evidence. The other form, and this is the more common form, is indirect evidence, where a typical example of that is, let's say somebody 65 is terminated. And then all of a sudden, they're told their job is eliminated. And then all of a sudden, the job isn't eliminated. Their task just was delegated to someone 30 and somebody 40, somebody significantly younger. And significant is generally considered 10 years or more younger. Okay. That would be an example of indirect discrimination. All right. Now, okay, so let's say you get over that hurdle, you establish what's called in law a prima facie case. The burden shifts to the employer to show that there's a business related reason for whatever the adverse action was. Inevitably, the employer has some business related reason. And then the burden shifts back to the individual to show that that reason may be false, like what's called a pretext. And so, for example, let's say somebody is terminated for poor performance. That's often in an age case, the justification. But if they have a track record of very good performance reviews, that would be an example of where you've raised the question of fact that it could be age. If there is just inconsistency, if there is like one case where a case I did where they actually had numeric scores, and my client scored higher than the individual, much higher than the individual got the job. That's a good case. Those are few and far between where there's documentary evidence of age discrimination. So that's how those are the various ways that age discrimination can surface.
Plays out. I know we're going to talk more specifically about hiring and age discrimination and hiring in a moment, but a question that kept popping up was, how would one know if you were discriminated against in the hiring process? I mean, I hear all the time because I'm very active on LinkedIn. I think that's how you and I first met. Um, I hear all the time about people, applying for jobs for which they believe they're very well qualified for. Hear nothing, that's a common thing going on anyway. But because employers aren't required to tell you why they did or did not hire you, how can you know?
Failure to hire cases of any kind of discrimination are the most difficult employment claim because of exactly what you mentioned.
Yeah.
How do you know? So one way is to try to find out who was hired for the position. And even if you do find out where, often, so hire is then often in cases, I have done some failure to hire cases, is the employer will say, well, they just didn't interview as well. This person we hired, they were younger, they interviewed much better. So, that's the one thing that I think, those proving failure to hire cases is not getting any easier.
Yeah.
And, but that's, you do need to find out who was hired, because even if you are great on paper, there's always, the possibility of the employer saying you didn't interview well. And it's such a subjective standard. It's, how do you prove you did interview well?
Yeah.
You know?
So I want to ask, we are talking here mostly about workplace age discrimination, but you also are an expert in disability discrimination. You co-authored a book on disability discrimination in the workplace. What lessons did you learn in that arena that maybe could benefit older workers?
I think one of the most important ones is focus on what you control. I remember, for example, in the Americans with Disabilities Act, uh, one of the changes is an employer can't ask about the person whether or not they have a disability. That before the Americans with Disabilities Act, they could. So I was talking to a group and explaining them about the law, and so one of the individuals in the audience said, "Well, that's good, but I'm in a wheelchair. I go into an interview. The fact that they can't ask me, how did you become disabled, doesn't mean I'm not going to be, still subject to the same sorts of discrimination."
Right.
And so that's one of the things I learned, is really there are some things you can't control. So you have to really focus on what you do control. Now, you just wrote an article that I thought was excellent on LinkedIn, about the fact that the job market seems to be frozen.
Right.
Okay. So that may be something we can't control. So the question is not just, okay, well then, what's the point, is, okay, what can I do about it? And you make various suggestions of how to, kind of get around those sorts of barriers. That's something, again, that word barrier, because people with disabilities face many barriers, and how do you get around that barrier? How do you get around that challenge? Sometimes you can't.
Yeah.
Other times you can, and to really think creatively and be resilient. You're going to get knocked down, get back up.
Right.
And so it's really, and also one of the most important things is a positive mindset.
Right.
That's something I tell every client I end most conversations with: think positive.
Yeah.
Because that to me has such that includes when the job search, which I know that's tough. I mean, if someone's been out looking for a job for 6 months, me saying it, who's in a very good law firm, think positive, it's not really going to resonate.
Right.
But it does make a huge difference. It's made a huge difference throughout my career representing people with disabilities.
Yeah. Gary, thank you for that. And for those of you who weren't here for our last coffee chat with Lisa from Workforce Boulder County, I wrote an article about that that's on LinkedIn and some of her tips for kind of navigating through this really tough job market. And we also have a YouTube video, and I'll be sharing that along with the video of this recording after this session. Um, there's been a lot of criticism of the federal law. And I think, especially as a result of a Supreme Court decision that kind of shifted the burden of proof, some decisions that came out of Court of Appeals that said the federal law didn't apply to hiring. Talk to us about that. Um, what protections do exist under the Age Discrimination and Employment Act? Where do they fall short, and what would you like to see happen? If you could wave a magic wand and say, let's get this law perfect, what would it look like?
Okay. The first thing would be to provide for remedies that mirror the remedies for Title VII. I mean, disability discrimination under ADA, Title VII, gender discrimination, race discrimination. The remedies include compensatory damages, emotional distress, as well as potentially punitive damages if you can show the actions were made maliciously. Those are not remedies under the ADEA. So that's the biggest thing I would change. Now there is one benefit under the Age Discrimination and Employment Act. It provides for the potential of double damages. If you prove it was willful discrimination. Practical reality is that doesn't benefit as much. It may benefit if you go to a jury, but when I'm negotiating an age case, the focus when you're negotiating a discrimination cases of any kind is loss of wages. And
Mhm.
even where I have extreme, very good evidence saying that, hey, we could go to a jury and get double damages, you're generally not going to, the maximum is still whatever the wage loss is. Whereas in a disability case or a gender case, I'm outlining and making a specific component for emotional distress damages. Termination for discriminatory reason is emotionally traumatic. To give you an example, where within what's called the Second Circuit, where Connecticut is part of the Second Circuit, a judge did a survey back, 8 years ago on emotional distress awards. And in what, garden variety emotional distress, the average range of an award by a jury was 30 to 125,000. So that's a powerful remedy that I don't have under the federal law in age discrimination. The other big problem, and this shares, the challenge with the age, or I should say, like gender discrimination, race, disability, is what's called the but-for standard. And that, to me, it's a particular problem in the area of age. Because let's say an employer has made ageist comments, the CEO said, Gary, when are you going to retire? And then I'm included in a reduction in force a month later. And I say, well, I think I was included in that reduction in force because of the fact that you wanted me to retire, or you were encouraging me to retire. Employer can say, well, even if it was age, we would have made the same decision. So that case would be dismissed, even if they admit that age may have been a factor. Whereas what that used to be the law until a Supreme Court changed it was it just had to be a motivating factor. So in that case, I'd still prevail. Now that's an example why I also want to tell everybody, also look into your state law. So for example, in Connecticut, under the Connecticut, what's called Connecticut Fair Employment Practices Act, it's a different standard. It's the old standard of just saying it's a motivating factor. And that really what I think the law should be, because the idea that an employer could say, yes, age was part of our decision, but the case would still be dismissed is a huge problem.
Um, so we're talking about federal law. You've just brought up the idea that sometimes state laws are going to be stronger. I know in Colorado, we worked really hard over a period of years to get stronger age discrimination laws here. Um, how do people find lawyers that are knowledgeable in in the law of their own state?
Okay, good question. The best resource is an organization called National Employment Lawyers Association. And that's lawyers who at least 50% of their practice is representing individuals in an employment law matter. And it's a very powerful organization that refers cases, has all sorts of training. It's something that they get involved. Sometimes courts will ask them to submit briefs on cutting edge issues that they're facing. And so the organization is based in San Francisco. There's also an office in Washington, and it's known as NELA, NELA. If somebody Googles NELA, they will find the organization, and they will help with referring lawyers within individual states.
Okay.
And so within that, often it's just, I always recommend, word of mouth of where to get the best lawyers. I really recommend avoiding lawyers if they don't have this as an area of expertise. So many areas of law, it's changing so rapidly.
Right.
And so having a lawyer who is well known in the employment law arena, I think, is extremely important.
So we'll include when we send out kind of resources after this session, we'll include a link to the National Employment Lawyers Association. And so great reference. I kind of have a follow-up question. It's something that popped up in the chat. When someone is calling an employment lawyer, like somebody said, I'm unemployed, how do I afford a lawyer? Talk to me about that. And very often what I'm seeing is, and we know this is true in general for older adults, once pushed out of the workplace, it takes much longer to get back in
Right.
than it does for younger people. If people don't have money, how do they access an employment lawyer?
The first thing is when contacting a lawyer is best to be upfront. Most employment lawyers I know charge a consultation fee. It's often the equivalent of 1 hour. Many don't.
Mhm.
Many will just meet with the individual, ask them to send us, a summary of whatever evidence they may have. And so that's one of the, one way. It is harder, because employment cases are can be difficult cases. One of the things that I always recommend, though, is also just in calling a lawyer is to try to see, are they more open-minded? I know a lot of lawyers will say, well, you don't have I don't know if you have a case.
Mhm.
And to me, I was trained by, the people I've worked with is to not just think of it as a case, but think of it as a problem.
Mhm.
Because usually right from the start, they don't necessarily, an individual doesn't necessarily know if age was a factor. So that lawyer can sort of, kind of navigate, well, but it usually I think if people can just find, for example, my consultation fee, $500. It's such an important issue to make the investment to at least meet with the lawyer to represent, for a consultation. Often what you then do is try to negotiate a settlement before you file anything. And, I find, at least based on my experience, about 50% of the time, we're able to negotiate a settlement. May not be, all of what their damages are, but it's a way to, in many ways, try to cut their losses and move on. Other than that, though, you're right. The litigation. There are still lawyers who do it, and if it's a very strong case, lawyers may represent them on a contingent fee basis. But it is a little different from personal injury law, where everything is just on a contingent basis.
So that's really helpful because I know some people are under the impression that it is on contingency basis. And I also know how complicated these cases are. So I appreciate you kind of filling us in. Let's dig a little deeper into age discrimination in hiring. Um, how does, in your experience, age bias actually show up in hiring practices? And are there things that job seekers can do to kind of avoid being caught up in being filtered out based on age?
I think what initially what I think I wouldn't. I'm going to give you an example of where somebody says, if I was asked about my age and I told them in the interview, you can't say that. All right. I wouldn't recommend doing that. If I would wait to see if you get the job. It
Mhm.
could have been a not necessarily a discriminatory question. Sometimes people ask about those sort of things without ill intent, even if they are don't intend to discriminate, may ask about something that, but then if you don't get the position, to then follow up, ask about it, I believe I was qualified, send a letter, go to a lawyer.
Yeah.
There may be other steps. And there are sometimes may be ways to, it's hard because there's so many variables with respect to hiring.
Right.
So one of the other examples is that that I've done is, are they continuing to hire? If somebody is so to because ultimately a lot of what age is, any form of discrimination is proving what the employer said is false. I've had clients who are told, well, um, we decided not to hire anybody, and then the individuals follow up and find out they hired somebody.
Right.
Or they continue to advertise for a position, or with clients who were working and are terminated, we're eliminating your position, and then all of a sudden I've had clients where they see their job when they're on their job search. It's like, wait a minute, that's my job.
Yes.
But again, with hiring is to practical reality again, toughest sort of claim, an employment claim. But wait to see was there inquiries made? Sometimes they are.
Right.
And so is just get through the interview and then follow up, kind of pick and choose your battles. Did they send did they have a form where essentially they, or if they ask you even, what year did you graduate? Those are in Colorado, I think that Colorado's way beyond most states as far as limiting inquiries. Most states, that's not the case.
Right. So I know, and we're very proud of what we did in Colorado. It was a really a coalition effort to
Yeah.
eliminate age and graduation dates from initial job applications. Let me ask you this, a few more questions about what might come up in an interview. So one of the questions that we received is, what do I do if in an interview somebody says, well, how many years have you been in this business? Or ask about the ages of your children, for example. Is your advice the same? Just wait until find out whether you got the job or not? Or how do you handle those kind of questions that could, that are indicators of age?
Advice would be to just answer the questions,
Yeah.
see what happens. Because if you say you can't, if you are straightforward and said you really can't ask me those questions, chances are you're not going to get an offer or a
Right.
follow-up. And they'll come up with a different reason. So to go through to see, because again, it may have been an inquiry that wasn't discriminatory, but let's assume it is. If that's what they were fishing around for and looking for information, and then you don't get the offer, then at least you may have some evidence going forward. And what I would do, what I would advise, let's take that situation where somebody asked what are the ages of your children, and then they find out they weren't hired. I'd send an email and say, I really don't think that was an appropriate question. Wait to see if they deny it or if they respond. They say, I'm sorry. And with that, also say, I believe I was very qualified, and maybe even ask about who was hired.
Mhm.
Because then I'm a big fan of the what I call the reverse paper trail. Because a
Yeah.
lot of employers will lay a paper trail, and then you go to an attorney, and then all of a sudden you have a litany of a paper trail against the person. So this would be an example of where I want to say on paper, and have a document where I've inquired about them. And if they don't respond, to me, that's also evidence. A non-response is a response. They didn't deny it. And so it really, again, depends on the situation as with respect how it comes up in the hiring process.
Yeah. I love that idea of a reverse paper trail. Let's talk about what happens when you're on the job. And I hear about this stuff a lot. You know, it's not only people kind of dropping by and saying, "Oh, are you ready to retire yet?" But it is things like being excluded from meetings that you were always a part of, or kind of being not getting an official demotion, but all of a sudden else is in charge of what you used to be in charge of and whatever. Tell us more, Gary, about your experience about how the different ways that it shows up in the workplace in a way that may offend or break workplace age discrimination laws. Again, looking at the federal law.
Okay. And this
That
is
was a
where most
long-winded question, but
right.
you know what I mean.
Yes, this is where most age cases that I've handled come from, and I think most employment lawyers. A variety of ways. One is all of a sudden you've had a strong track record of very good performance reviews. All of a sudden you get a bad review. It may be where you see there's been a hiring of just really young people, and other older individuals suddenly either retiring voluntarily or just being terminated. So you look at the demographics of hiring and termination. Where there's a change in supervision, where you've been working for somebody for a long time, and then a new supervisor comes in, and all of a sudden you can't do anything right, particularly if it's a younger supervisor. If the so the most common thing is, again, all of a sudden a significant change in the nature of the performance reviews. So other things are things like on the, I have a case now where somebody had been there, 32 years. All of a sudden they hire somebody who's, in mid 30s. That person, because this is also where the person's intertwined with involved with media, is all of a sudden he's not doing many, media appearances. The younger person is, and it looks like he's being gradually replaced. Those are the way, a variety of ways where, and another you mentioned was all of a sudden there's very important meetings and you're not being invited to them, and there's no reason why of where they used to be in management. So it's almost like easing out. The other is just where it's the extreme, where a lot of times with employers is and I'll say this to clients, is the one thing never ever to do is resign. Because not only are you walking
I want
away
to pause
from,
and reinforce that to everyone.
right,
Never, never resign. Tell us why, Gary.
because number one, if you resign, you can't get unemployment in most states. Because you would need to prove constructive discharge, like in effect, anybody would have resigned. It is such a high standard to beat that generally if the employer just says, hey, we wanted to continue to employ them, but they resigned, it's not our fault. Secondly, if you are going to be, because a lot of times if I have a client coming to me where all the indications are they're being set up to be terminated, I don't wait for them to be terminated. Like some lawyers will say, well, wait to be terminated, then you'll have a case. To me, they got a problem. And that's really what I focus on is, okay, what can I do? Can we negotiate preemptively? Because that's one of the things that let's make the assumption that they are generally trying to push this person out because of their age. Okay, I want to interfere. I want to throw a wrench in that process where they might be just laying a paper trail. So one is, again, if they're being criticized for things and it's unjust, is to respond and say, that's not the case, to do the reverse paper trail. At some point to say, I believe this is happening because of age. And so then if we decide I'm going to intervene as the lawyer, I will send a letter and then remind them, oh, by the way, the Age Discrimination Act also prohibits retaliation. So don't retaliate against my client, or that'll be a new claim. Because if somebody's retaliated against, that can be separate and apart, even though it wasn't age discrimination if the employer gets upset. And unfortunately, retaliation is a component if you're raising your legal rights throughout while you're still employed. Now, what I tell every client though is once I get involved as far as notifying the employer, I believe, my client's being discriminated against, the overwhelming majority of the time is how that relationship is going to end is with a negotiated severance agreement. It's hard to undo, where the employer says, "Oh, in that case, we'll just stop. We'll back off." Where I send a letter, often clients will be concerned, where they'll say they're just going to, start treating me even worse. And so what I've said is often that may be the case. What I find more often is, what I refer to as dead man walking. It's like people all of a sudden won't talk to you, won't because they're nervous. They've been told don't deal with you. That's hard for individuals to go through.
Right.
But they have the added leverage of if the employer then turns around and terminates them right away, they've just created a new claim. And so it lends itself to more of where I'm maximizing my client's negotiating leverage, because that most cases are resolved at some point. And so when somebody again comes to me, I'm getting back to my initial question that I ask everyone is, what's your objective? Right. Nobody comes to me and says, I want to litigate a case for the next 2 or 3 years.
Yeah.
But they have a big problem. And so litigation is kind of a tool in the toolbox. Negotiating behind the scenes. There's various ways you can try to solve the problem. One of which way it may not be age discrimination. So before making that jump of where I intervene is kind of testing out, is that really the case? And if it's something, a lot of it is if there, because something, I really have to look at objectively is, has your performance declined? Is it something other than age discrimination? Is it maybe you're not, this job isn't a good fit anymore. But once you really say, I think it's age, that's when I think you gotta, as a lawyer, I jump in. But it's always with the caveat of to explain to the client, it's not like they're going to say, gee, I never thought of that. I guess we are ageist. It's going to end, it's like what I call is the workplace divorce.
So this has raised a bunch more questions in my mind. So you mentioned this idea of reverse paper trail. Who do you send this email or letter to? Are you sending it to HR, or who are you sending this letter to if you're saying, hey, wait a minute?
Depends on who is taking the adverse action against you. Yeah. And then it depends on, again, if it's a larger employer that has an HR department, I might, if it's a supervisor who did something that I think it's, if they were claim that, that if it looks like just a false allegation, I have clients send a letter, and not in an angry way, but more like a typical business email. This didn't happen. And copy HR on the email, somebody in the human resources department. So you've sent a message. Okay. Another thing, in certain states like Connecticut, you can get a copy of your personnel file. Mm-hmm. And sometimes I find out very valuable information from that. But I also tell clients, even if I don't do it, even if they do it individually, it's a red flag. Like, right. Okay, why is this person suddenly want a copy of their personnel file? Gee, I wonder if they're talking to a lawyer. So there's risk. And, speaking up, because I think people, one way is to speak up on behalf of yourself if you feel like you're being discriminated against. But I usually strongly recommend if you're going to do that, do it in an email or some way so there's documentation. Because much more often than not, unless there's some documentation, I will hear, oh, they never, we couldn't corroborate that they actually said that.
Right. So, and speaking of speaking up, we have a bunch of what I would call upstanders in our community. So, several people asked ahead of time questions about if they see something going on with someone else, should they speak up, or does it put a target on their own back? Thoughts about that?
You know, um, again, that's something where you have to, I think, really pick and choose your battles. It depends on what it is.
Yeah.
If you hear like a coworker say, Gary, have you thought about retirement? If somebody called me and said, I say, I think that's wrong. I'd say, yeah, it is wrong. Maybe you speak to that person, the coworker,
Yeah.
but I wouldn't document it because that's not somebody who necessarily would have had control over their employment or might be asking that question to terminate them. Whereas if that's a supervisor who says, like one case I'm asking now, it's like, do you know everybody wants you to retire? And that's a higher, someone higher up on the food chain. That would be something where I'd say that you should document that because chances are you're vulnerable right now. So you need to do something, such as send an email to HR and the person that made that statement. So, I tried, it's a good, very good question, but it doesn't lend itself to a black and white answer.
Okay. So upstanders out there, you've heard what you maybe might want to do. Um, a final question about what you've just talked about is, um, so one of the things that I've heard people say is, or employers saying, well, older people just cost too much, so we're going to get rid of them and hire younger people that we pay less. Is that a legit reason to get rid of someone older?
That and you know what? That this is the perfect example of what I said about the but for case.
Yeah.
Because if an employer, it used to be if some employer, because who makes more money? Generally, people are working there longer, and so um, the employer may say, "Well, we didn't terminate them for age. We were just, we wanted to reduce our expenses, and that person happened to be the highest paid. Just so happened they also were older." Those cases are tougher cases now because the case law has been, well, that's not age discrimination, that's economics.
Yeah.
And so those are more difficult cases. The but at the same time, even in those cases, it's often with other evidence before the
Mhm.
person is terminated, such as an attempt to try to get them to quit.
Yeah.
The easiest thing for an employer is if they want to discriminate based on age is to try to, if they get them to quit, that's the best alternative.
Right.
So they often will do things first before they pull the trigger and terminate the person, So but and it's one of those things where it depends on the case law within the circuit court, the area of the country. Certain areas like in our areas, the Second Circuit, Northeast tend to be more pro-employee as far as the decisions. This is not. This is one of those areas where it's not always clear, but more and more courts have said if you're just motivated by reducing cost, then that's a lawful business related discriminatory reason. What you then need is evidence to contradict that. Other decisions, perhaps, that the employer made that made no financial sense.
Right.
Um, or like in they hire new people. So yes, but that's a tough issue. It's why it would be so much better if and when another, I have up here behind me the United States Congress, the House and Senate. Not going to happen in the next 2 years where you're going to see an expansion of the Age Discrimination Act, practical reality. But that's something that would really help is if the age law were changed so it's a motivating factor is considered age discrimination and not a but for test.
Okay. So Gary, you brought up our current political climate, Congress. We had several questions come up about some of the executive orders, for example, about DEI, that seem and other executive, pushing federal workers out, that kind of thing. How do you see all of that kind of intersecting with what's going on in age discrimination law and affecting cases for workplace age discrimination one way or another?
Kristen, controversial question in the employment law field,
Yeah,
because we're now it's so much as with DEI, diversity, equity, inclusion. To a large extent, age was never included in that equation.
that's
It
been my
was,
spiel for a long time that it
yeah.
should have been. Yeah,
And so the fact that now that's being attacked as being including by the Equal Employment Opportunity Commission, which in the past has been a force in enforcing discrimination law. Everything has changed in the last few weeks, and it's not going to change in the next 40 years.
yeah,
And that's one of the things that I think we have to accept. And so I don't think that in itself is going to make change the fight against age discrimination. I think where it will be is the layoffs that are likely going to happen within every agency. If it hasn't been hit the EEOC yet, it will,
mhm,
because it's taking longer for the EEOC to enforce, with if you're reducing the workforce, it's just going to make cases harder with the EEOC. At the same time, and that's why, NELA is very important. The overwhelming majority of cases, the EEOC is where you can go to file a claim, particularly if you don't have an attorney. In a lot of states like Connecticut, it's really the battle is really fought within the state Fair Employment Agency,
okay,
but is through private lawyers of enforcing age discrimination. So I don't see necessarily that the political climate with respect to now anti-DEI is going to change for age. I think it's going to be more of the fact that I think EEOC is going to sort of pull back on all employment rights, generally speaking,
yeah,
on behalf of individuals, because um, uh, that just tends to be the case, and trying to be non-political. But in Republican administration, the Congress, depending on who's in charge, if a Republican in the House is in charge, they're not saying we're going to increase EEOC funding. They decrease it. What does that result in? Layoffs.
yeah,
And this is not a usual environment for layoffs, as we all know.
right,
Um, what will also be important, though, at least at the federal level, is that is who the judges are, because those are the judges, again, interpreting the law. It's one of the reasons, though, I also would strongly recommend that people really look at their state law.
yeah,
I think the changes in the federal level is going to result in people, as has happened already, really focusing and as far as pursuing employment discrimination cases more at the state law level.
right. Okay, thank you. That's really helpful. We received a couple of questions from people about what happens when you're kind of pushed out or laid off. A couple of people shared, they were asked to sign severance agreements, waivers, and that kind of thing. When you receive that kind of, when you're called in and someone says, you're fired, you're laid off, I think people are naturally in shock and maybe not necessarily thinking straight. What do people need to do when that document is put in front of them and said, you'll get severance if you sign this?
Most important thing I tell people is what not to do.
Okay.
Um,
Tell us what not
don't
to do. Yeah.
don't argue. You can't. It's not like you're going to talk them out of it. Don't if you kind of get angry. It's not human nature. It's emotional, particularly if you've been working there a long time. So that you can't control. But don't do something out of anger, because it's not going to help, and it's not going to help with potential negotiation. I really think the important thing, I've suggested clients who think they're about to get in a RIF, a reduction in force, if that's going to be coming, is ask, well, why was I terminated? Me in particular. And they'll only ask that. Don't try to challenge it, because most HR people are skilled enough where they say very little. But sometimes they say more, because when they come to me, and I definitely recommend people go where they're offered a severance, go to an attorney. you're entering into a contract. The employer had lawyers, drafting the contract, and it is, a waiver of legal claims is a contract. So the first thing is for that lawyer to look at under the Older Workers Benefits Protection Act. And that is something actually, again, that's beneficial for age discrimination that was passed in, I think it was 89, is the employer is required to provide the ages and job titles of those kept on and those let go. So to get a look at those numbers, that's a kind of it gives you not a better idea of was age a factor, not just sort of adding up and what does the numbers add up to. I do that in the case, but then I really focus on, okay, specifically within my client's area, who is kept on. Now, if if in my client's department there were 10 people, working and 5 of them were terminated, that's what I focus more on is who are the 5? What are their ages? And usually you can tell from that list. They don't list the names, but you usually get very good information. So that's where I do, one of two things. One is there room to negotiate when somebody comes to me? Then, you outline the case, because there's 45 days within which you get more of a time frame if it's a group termination to negotiate. Mm-hmm. Being realistic. One of my mentors in negotiating said, negotiating is like fishing. You got to be close enough to the fish. Don't come up with a huge number, to be practical, because one of the reasons why some employers are resistant is, as much as that document will say you can't tell anybody, most employers think word's going to get around. So if I offer this person more, then word will get around. So sometimes they're resistant, but not necessarily. And that's one of the reasons why I often will say, let's wait a few weeks, because most times people, when they're terminated, they return documents right away. So that's one thing I'd suggest is don't return documents right away. You'll have more leverage if you're a little patient. Okay. So don't panic. Don't, sign it and return it right away. But then once most, people have already responded, I think employers are more willing to negotiate. But you have to be prepared to have evidence that might refute their reason. And that may be, sometimes there's criteria as to what the criteria used, to be prepared to address that, to at least make plausible arguments that it was pretextual. Now, let's say I look at the numbers, I talk to my client, there is really just where I just don't think there's any basis for age discrimination. I'll tell them, and if you made the investment to at least have a lawyer looking at it, whether it was an hour or 2 hours. The other thing, though, is particularly with long-term employees, is one thing they likely have is goodwill, a reservoir of goodwill. Who can you go to within management who might go to bat for you internally? So there's other ways other than just, potential age discrimination claim, where you might have leverage to try to negotiate an enhanced severance. You might be able to do, although most employers these days won't provide reference letters, is to provide a reference letter, perhaps to negotiate COBRA payments over a certain time period. So really, as long as you come back with something that's realistic, that makes it hard for the employer to just say no, those are ways that you might be able to negotiate. But the one thing that I always tell people, because they say I want to go back to work, is that's virtually impossible. Once they've chosen to terminate you, it's likely not going to happen. The other cases are just where it's just an individual termination. That's where you have 21 days to consider the release. It really depends on the individual circumstance of why you were chosen. The same thing, I'd still encourage people to go to an attorney so you can evaluate what, if any, claim there may be.
So what about this, though? suppose they're just putting the paper in front of you and they're insisting you sign it right there. I guess my answer would be just walk out of the room, but what would your answer be? You're the expert.
Same thing is well, don't walk out of the room. Take the paper with you.
Okay, take
um,
the paper.
right,
Okay.
because the again OWBPA, the Older Workers Benefits Protection Act, they have, if it's a valid release, they have to provide you with 45 days to consider it.
Okay.
Okay. So now I've had some times where it seems like it's a good age claim, and this would be more where it's an individual is, hey, inquiries from their supervisor or HR, you going to sign it? You going to sign it? We really need to sign it. And those are usually cases where the employer's worried and they want if they say, we need to, we need it back in a week. Well, I know that that would be if they return it in a week. And sometimes, somebody may do that just out of panicking, but
Mhm.
it's illegal. They have to give them the required number of days. But I have had cases where clients are told you really need to return it sooner. You don't want to use up all your time, you know use the time that whatever is in the release. And if you're being hounded about when are you going to sign it, generally that's a red flag that they're nervous about a discrimination claim.
Great advice. Good to know. So we only have a few minutes left. I have two more questions for you, Gary. Meanwhile, Gary again has offered an hour free consultation to whoever wins the drawing, but I don't want you to have to put your name in the chat so you can preserve your confidentiality. What I'm doing is I am putting a link in the chat. If you are interested in being entered into this drawing, you could just click into that link. All you're doing is entering your name and your email address. I will do a random drawing after this session. And if you are selected, I will simply connect you with Gary. If you're not selected, we're not sending out a mass email or anything to anyone. But whoever is selected, and I will do that literally within an hour. So if you want to be considered, go ahead, click into that link that's in the chat. All you have to do is enter your first name and email address. So, Gary, of my two remaining questions, what about when government agencies are the perpetrators, if you will? Do government immunity laws apply to age discrimination cases? How does that work?
No, you still go through the same uh well, if it's a federal worker, they have their own kind of enforcement system of where, going about filing a claim. But if there's nothing that would make if it's like a state or local government, they're still subject to the Age Discrimination and Employment Act. So you
Okay.
still go through the same process. Well, actually, uh, it would be, you actually file with the Justice Department as far as, if you're a governmental employee,
Okay.
but same process. What happens is when you have to start by filing with an agency, but you also, and again, it depends on the state. Like that, I'd still file even if it's a municipality. I'd file the federal claim with Department of Justice, but the state law claim in Connecticut, the state has jurisdiction over that. So I'd still file with the state. What happens, just without going through all the ramifications, is a claim has to remain with the agency for at least 6 months
Okay.
before you may request a right to sue to file the claim in court. That's always one possible avenue that you might want to pursue.
Okay, great. Thank you. I like to leave things on an optimistic note, especially this year. My mantra is, to make hope possible instead of despair convincing. You wrote in an article this fall about you were optimistic about some of this stuff. What are you optimistic about right now?
Because there is a need, looking at the kind of the big picture beyond just, because and getting back to that article, what I had said was age discrimination is flourishing, but the reason for optimism. And some of the people read it, it's like, wait a minute, you can't have both. And so I'd say, well, actually, you can. because it is flourishing. Yet there's a need for people to work more. If you look at the demographic trends, is there is less, there's less and less people being born, and people are working longer and longer.
Right.
And I think a good illustration of that is right now, there's a record number of people retiring who are 65. At the same time, there's a record number of people who are 65 who continue to work. I think you're seeing just more in so many avenues of society, of people who are working longer, and along with the need to work longer. But I think employers, not all, but a lot of employers are realizing we need,
Right.
people who are good mentors, who are good at what they do. And that's why one of the things I always suggest to people is think about what can you do that might be using your age to your advantage.
Yeah.
And so, and I always think of when I had there less and less, I think the stereotype against age, I think, is decreasing. We have when I'm a big sports fan, we have a Rick Pitino, 72-year-old St. John's coach who is, had St. John's and has a top 10 in the country in his second year with the school. Bill Belichick being hired to run University of North Carolina at 72. Pete Carroll being hired by Las Vegas Raiders at 73.
You are a sports guy. You are.
Yeah.
Yeah.
Harrison Ford,
Yeah.
in like every new streaming series or movies at 83. And so those are just examples, but the more and more people are continuing to work and excelling.
Yeah.
And I think you're also seeing employers who see the benefits of intergenerational workplaces, of balancing the younger workers with older workers, that collectively they're better.
And Gary, you were singing my song. That's what I preach to employers every day. We are at time. Thank you so much for joining us and for sharing so much insight and wisdom. I'm feeling everybody would love to hear you talk well on into a Friday afternoon happy hour, but I'm going to let you go. Really appreciate it. Everyone who has joined us, we will be sending probably early next week a recording of this along with some resources. Thank you all so much. Take care. Have a wonderful weekend, everyone. Gary, thank
Thanks,
you.
Janine. Thank you.
Bye.
Thank you, Janine. Thank you, Gary.
Oh,
Thank
Bob, I
you.
love
Good
seeing
hearing
you the
you again.
holidays. Yeah.
Oh, good. Thanks.
Bye.
Thank you.